Hello and welcome to today's webinar, examining Russian data privacy law, the GDPR, and their impact on online business. My name is Holly Hyams, and I'm one of Data Guidance, APAC, and CIS privacy analysts. I'm delighted to be joined today by expert speakers Sergey Medvedev, Stanislav Rumyantsev, and Anton Zubkov. Sergey Medvedev is a senior lawyer in Gorodissky Partners Moscow office. Sergey works in the Intellectual Property and Technology, Media and Telecommunications Group. In relation to data protection and privacy, Mr. Medvedev deals regularly with a wide range of areas, including data management, documentation formalities, data security and breaches, international data transfers, and national data processing issues. Stanislav Rumyantsev is a senior lawyer at Gorodissky Partners. Stanislav specializes in e-commerce, cloud computing services, software development, and IT sourcing matters. He has carried out full-scale personal data compliance projects for international and Russian companies, including, among other things, localizing corporate GDPR policies. Anton Zubkov is the head of technology and modernization services of Tieto in Russia. Anton has worked at Tieto for 11 years and has gained experience with dozens of European and US companies operating in the Russian market. Thank you all for joining us today and taking the time to share your thoughts on this area. During this webinar, Anton will first delve into industry-specific practice, and secondly, Stanislav and Sergey will share their experience on legal compliance within Russian data privacy law. As well as this, there'll be a chance for listeners to submit questions to our expert speakers, which may be done using the chat box appearing at the bottom of your control panel. We will try to address as many of your questions as possible, time permitting. As this webinar will run over the course of an hour, I will now swiftly hand you over to Anton to commence the discussion.
Thank you, Holly, and hello, everyone. So I'm Anton from Tieto, and I represent this IT company responsible for cloud-related business in Russia. My team serves a number of international companies coming with online business to the Russian market. And I will share this experience with you as an introduction for our today's topic, leaving legal interpretation for my colleagues in the next part of our webinar. So I will first describe Tieto as an example of the data processor available on the Russian market. Then I will make an overview of the particular cases we've had here. And finally, I will describe how we can handle paperwork in regards to GDPR. So let's start. Tieto is a 50-year-old company headquartered in Finland, operating in most of the countries worldwide, and present with its personnel and facilities in 20 countries, and Russia one of these. As for the relevance of Tieto as a data processor, we can mention Forrester recognition as a strong performer last year. This year we were recognized by Thomson Reuters among top 100 technology leaders in the world, and so on. And specifically about Russia, we're for 22 years now here, and our portfolio is nowadays more than 150 customers from across all over the world. And beside my technology services and modernization business, we have also system integration and industry-specific practices here on local market. What is important for today's topic, Tieto operates data centers in Russia. Both are located in Moscow and have one of the most modern, reliable power supply, cooling, and all these important infrastructure arrangements together with solid maintenance and security. Thus, it can be a proper place for the personal data hosting. Now coming to our experience with the personal data in Russia. So we are very careful about our customers' confidentiality and don't tell the names here, so you know many of them when you go for shopping, drive a car, or have something else to do with manufacturing, retail, telecom, finance, and other industries. So brands and companies should be very familiar for you. Companies are from all over the world, from US to Japan, many European countries, as well as UK. And scale varies from biggest in the world to the smallest European players with the need for compact solution for their Russian operations. And that is good news for today. So whatever is country, industry, and scale, we managed to deliver and comply together with our customers. Many rollouts took just several days. Longer stories were either about legal and security paperwork for large corporation, and less about solution architecture and technical stuff. So here on this slide, I summarized how companies treated the compliance from my experience choosing the location of their system. So location is one of the primary issues, to my opinion, in this area. I split it to three basic scenarios. For example, marketing-related systems, CRMs, primarily are hosted in Russia completely. These are listed on the left. Though there are a number of occasions when we utilized existing customer systems abroad and put only a small piece in Russian data center, so avoided to reinvent the wheel totally. That's in the middle of the list. For example, HR, BI, and some cases of internet shops. What is not the case in my practice is a local implementation of the corporate email. Quite a rare case, I would say. So this is mentioned on the right. There are some exceptions when email is used, for example, as a minor function of some marketing system, then it can be hosted locally. We have such stories. But otherwise, traditional corporate email can be wherever. For example, Cloud Office 365 is very well present here. My overall impression about personal data handling in Russia can be split into the two things. First, there were really a lot of actions for the Russian personal data legislation, especially the requirements for Russian hosted databases since 2014. But as for GDPR, many companies have done very little or even nothing additional. Additional, I mean, to what they had before GDPR introduction, and as much as surely visible for us as data processor. Some decided they don't process European personal data in their Russian operations. And as an example of additional measure, some companies undertaken, they changed, for example, consent text for their website visitors. That is to verify specifically if he or she is Russian citizen, not European one. As for the process and documentation changes, these measures often provided on a foreign headquarter level. Measures for Russian legislation compliance together with traditional corporate policies are often considered to be enough to comply with GDPR. So not that much additional were visible last and this year with GDPR introduction. And among reasoning, I often hear from companies are usually statements as follows. So all websites are hosted in Russia and are available only from Russia. All the website content is only for and in Russia. So these kind of reasonings. Well, and overall as a summary for this slide, so yes, a lot of systems require Russian hosting, and no, not everything needs to be migrated to Russia, and yes, hybrid solutions are possible, doable. On the previous slide, I mentioned BI as an example of the hybrid implementation. Here we see one of the cases we had. We launched BI solution for the customer Russian operations. Customer here is European, in some sense, US company. So we utilized a number of locations, including Tier 2 data center in Moscow, customer locations in Russia, Europe, and US, and consolidated everything using Amazon Web Services. On the next slide, you can see a bit more detailed view, but as not everyone here is up to technical details, I will not go deeper. just specifying here that internet shop and marketing databases are located on the left in Russian data center of Tieto. Data going to European locations of Amazon Cloud after the initial collection to these Russian databases and anonymizing. And similar with the data coming from customer locations in Russia and Europe mentioned on the right. So this picture and these stories tells us that this kind of mixture is really doable and perceived as compliant. And our legal colleagues later will come back to this principle later today. And here is one of the most simple use cases. European transport industry company sells tickets to its customers, and they had a website located in Europe together with its database. So in order to comply with Russian legislation, they decided not to replicate the website itself, but to split the database. And Russian part of database goes to the Tieto data center in Moscow. So it requires minimum technical work, provides compliance, and minimizes cost and complexity in this specific case. Having technical concept, you need to prove Tieto as a data processor is capable to provide you with a compliance with Russian legislation and GDPR. First thing to verify are service license from Russian authorities. So your processor has to have solid establishment in Russia. So you see this colorful papers here. Next, that's what is verified in more details by companies choosing processor in Russia. Structure of questions is common, but depending on the business case, scale can vary from several to dozens and up to hundreds questions and evidence requests. I worked with almost 200 pages questionnaires, passed audits, which took many weeks with number of customer experts from all over the world. Sometimes we were the only data processor in Russia who managed to prove to be trusted partner. So, though such a complex approach is really exceptional, in most cases it's enough to have standard and compact contract template. Tieto's one or your company template. This can be handled so without really need to reinvent the wheel. Having initial confidence in a processor for Russian operations, you might want to ensure continuous control of your data privacy, and that's not only by your own audits. One of the ways is ISO 27000 certification, in the case done by European auditor, and Russia is treated specifically and confirmed in the certificate appendix listing our locations in Russia. Well, if it happens you assume to process European personal data in Russia, we have Tieto digital data processing agreement. So this is quite standard contract template, ready-made one, covering everything required by GDPR for the relationships between data controller and data processor. So you can be patient, you've done enough in this regards. And in addition to DPA data processing agreement, we will sign standard contractual clauses as it's defined by the European Commissions. So to summarize, as I mentioned before, many international companies in Russia have had little measures for GDPR in addition to what they had before, at least as much as visible for the data processor. So let's listen what legal guys are saying about it. I'm completing my presentation and thank you very much for listening.
Thank you, Anton, for sharing your perspective on this area. I would like to now hand over the discussion to Stanislav.
Hello, Stanislav here, and now let's speak a bit about the legal part of the data privacy. Online business, Russian data privacy law versus GDPR. What does it mean? Now you may see the agenda on the screen. So we are going to tell you about the situations when Russian law apply to online business. Then we will say some words about the demonstration of compliance under the GDPR and under Russian law. Then we will compare key GDPR rules and Russian legal requirements in order to understand how international companies doing business in Russia must proceed with the compliance with both GDPR and Russian law. Then we will explain the key issues of legal liability under Russian law, and then we will summarize all this information. When does Russian law apply to online business? That's a tricky question, actually. Here on the screen, you may see a map. On the right side, this is Russia, and on the left side is European Union. Hence, on the left side are the lands of GDPR. Now let's imagine that we have an EU-based company here. And this company have something to offer to Russian clients, to Russian customers. This company may offer both physical services and online services. What can it be? This is the customer, and the customer would like to go to the European Union and receive some travel services, gambling services, medical treatment, private financial services, and maybe also some other things, especially the services which are either limited in Russia or prohibited in Russia, but fully accessible in the EU. In addition to the physical services, our customer may wish to receive online services, and usually they are cloud computing, online games, mobile apps, for example, fitness trackers, and also learning and training services, for example, online schools, online lectures, maybe online certification programs. There are many different options. How to provide these services to the Russian customer? First of all, we need to establish a communication channel, and that means that we need the internet here. The internet is somewhere in the middle between two jurisdictions. This is a kind of gray zone, and that's why it's gray on the screen. Now let's imagine that our company has a website. This is actually an international website with various localized versions, including Russian version, version in Russian language. The company now may offer physical services through the website, and it is possible to render online services through this website. It is also possible to connect this website to mobile applications. In addition to that, our company may offer some product delivery from the EU to Russia. So this can be an online store, and our customer may order something, for example, clothes, various equipment, sports goods, any other products, immediately from the European Union to Russia. So this is a kind of delivery across the border. And finally, it is possible that our company has an office in Russia, either a representative office or a branch office. In this case, the services can be provided either with the assistance of or through the intermediary of the representative office. So this is our landscape. This is the main picture of online business. Let's now try to understand where is the collision of laws. How does it happen? First of all, the GDPR applies across the borders in cases specified in the GDPR. What are these cases? First of all, the GDPR applies to the processing of personal data in the context of the activities of a company in the European Union, regardless of whether the processing takes place in the EU or not. It means that if the company established in the European Union receives Russian personal data, this personal data will be also processed within the Union in line with the GDPR. Another situation is that the local Russian office may be involved in international projects. Let's imagine that this website provides online gaming services, and the representative office may operate and administer online games. In this case, the players can be both in Russia and in the European Union, and the representative office will deal with personal data of both Russian customers and EU-based customers. In this case, GDPR says that the GDPR is applicable to the operations of this office because this office is a part of a global company on the one hand, and on the other hand, this office is involved in the monitoring of behavior of data subjects who are in the European Union. To sum up, now we see that almost all actors on this screen are covered by the GDPR in certain circumstances. And at the same time, Russian law may be in force, may be effective even beyond the borders of Russia. Of course, Russian law does not go that far as the GDPR, and that's why it is impossible to apply Russian law in respect of the company that is in the EU. But it is possible to cover the representative office of this company, and it is possible to cover the website, even if this website is an international one. Let's see what does the Russian data privacy law say about it. According to the Russian law, this law should apply to websites which are intended for the Russian market, meaning that these websites must be addressed to customers located in Russia. In addition to that, according to the explanations given by the Russian Data Protection Authority, Russian law applies to subsidiaries, representative offices, and branches of international companies if they are established in Russia. And from the perspective of the Russian law, representative offices and branches do not constitute separate legal entities. They are just business units of a non-Russian company. It means that the Russian authorities may address inquiries to the company and deliver these inquiries to the representative office. And if they bring the representative office to a Russian court, the claim will be addressed to the whole company. As I mentioned, the Russian personal data law applies if the website is intended for the Russian market. How to understand which website is affected? There are several criteria established by the Russian authorities. The Russian personal data law applies if one of the following applies. First of all, the Russian law applies if the website is created with a Russian domain name, and in addition to the domain name .ru, there are some more domain names which belong to Russia. In addition to that, Russian law will apply to global websites if there is a localized Russian version of this website. But taking into account that Russian language is a widespread language and it is used in many countries, there should be some additional criteria for applying Russian law to Russian versions of global websites. So for example, the Russian law will apply to a website established in .com zone if this website is in Russian, and in addition to that, if this website accepts payments in Russian rubles, or according to the terms and conditions published of this website, the customers must conclude an agreement which should be performed in Russia, for example, the delivery of goods. Or if there are any other circumstances clearly evidencing that the business strategy of the company includes Russian market. Now we understand that it is possible, and it is also a very common situation, that a website and online services provided through a website may be covered by both the GDPR on the one hand and by the Russian law on the other hand. And that is why the next question is how to demonstrate compliance. First of all, we should understand that if our company runs a global business in many jurisdictions, it is hardly possible to use different privacy policies and different end-user agreements in each particular jurisdiction. All companies try to unify their documents, their legal documents. And that's why let's imagine that here in our world, we have many offices belonging to one and the same company on different markets, and they all use one and the same web platform with localized versions for each particular market. From the perspective of the Russian law, it means that the website, at least the Russian version of the website, must contain data privacy documents that are prepared in line with Russian law. And from the GDPR perspective, this situation means that the documents must be in line with the GDPR. The question is, are the GDPR documents and Russian privacy documents identical? The answer is no, because the laws are different, but these laws are based on one and the same principles. And that's why we can use the GDPR documents as a basis, but still we need to do some localization work in order to apply these documents in Russia. What are these documents? According to our experience, the key documents under the GDPR are the privacy policy, various consent forms, end-user agreement, cookie policy, and cookie banner. Under the Russian law, cookie policy and cookie banner are not required because it is unclear under Russian law whether or not cookie files are personal data. End-user agreement is necessary, same as in the EU. And the privacy policy is necessary as well. But the terms and conditions of this privacy policy are slightly different in Russia. In addition to that, we should understand that if we have an office in Russia, this office must ensure full compliance with the Russian data privacy law. And in practical terms, it means that the Russian office must conduct a full-scale data privacy compliance project, including legal, organizational, and technical measures prescribed by Russian law. But still, let's focus on the documents that must be published on the website. And now let's speak in detail about the localization, how to do that, and what are the key points here. And now I will give the microphone to my colleague, Sergey Medvedev, who will let you know in details what to do based on his practical experience.
Thank you very much, Stanislav, for sharing the light on these very important things and differences between GDPR and Russian data privacy law. So let's speak about the localization and in particular when it and why it matters. First of all, let me show you that the concept and the definition of personal data is pretty much the same if to read the GDPR or if to read the Russian personal data law. According to the Russian personal data law, personal data is any information which is related to an identified or identifiable individual, physical person, which is considered a data subject. If you look at the GDPR concept of personal data, it is pretty much the same, although it gives you a few examples of what it can be and what information you can basically extract when you share this information with the others. The Russian data privacy law doesn't distinguish between the direct or indirect personal data, although the definition says that indirectly or directly one can identify the data subject. So for example, if it is just the name of the person, then this information cannot be treated as personal data according to the Russian law. If there is something more in addition, for example, the address of that person, the telephone number, the email address, then combining all these elements, we can treat this information as personal data according to Russian privacy law. Of course, there are some types of information which receive stronger protection than regular information. And this is, for example, is types of sensitive information like religion, political views, which can be sensitive from the point of view of personal data protection. And there are some other types like biometric data, for example, a copy of the passport of the person, which can also receive strict protection. And that is why in these cases, not just an informed or electronic consent, but written consent is required according to the law. Also, there are some differences in terms of pseudo data. In GDPR, there's a concept of pseudonymized data when some elements relating to a person can be allocated and stored in different data centers or databases, and still this information is treated as personal. In Russia, there is no such concept as pseudo data, and in Russian law, there is a similar concept or equivalent, which is called anonymized data. But the sense of that is a little bit different. The Russian law treated as if this data was destroyed and compared with destruction data when the purposes of collection and processing of personal data were achieved. In other words, this is the treatment with personal data when you finish to process this data. You can destruct it or you can anonymize this data. So this concept is a bit different from side animation data in GDPR. Also, there are differences in controllers and processors. First of all, in the sense that Russian law doesn't have a concept of data controller or data processor as they are determined in the GDPR. Instead, the Russian personal data law refers to the concepts of data operator and the person that is acting under the instructions of the data operator. So the data operator will always be a person that, first of all, determines the content and the purposes of personal data processing, and of course, the actions that need to be taken relating to such personal data. And the person that is acting under the instructions of the personal data is the person that has to act under the consent of the data subject, and it has to be a clear and written agreement between the data operator and a person that is acting under the instruction of the data operator. So these two concepts are similar to those defined by the GDPR, but still there are some specific features. So let's switch to key obligations of the data operators under the Russian law. Of course, there are many of them, and it will depend on a particular situation and on a particular purpose of data collection. But if we talk about the online business, which is the topic for today, first of all, the data operator, like Stanislav mentioned, has to care about the documents they have in their files and they place or post on their websites. I'm talking about the privacy policy, I'm talking about the consent of the data subject, and I'm talking about the cookie policy, which is being discussed nowadays actively, and I will talk about this later a bit when Russian IT regulator Roskomnadzor is planning to issue some clarifications on this point. Of course, a special internal audit must be conducted, and certain legal and technical measures have to be taken to produce some package of documentation. And believe me, this package of documentation is a bit strong and heavy. After all, if the company is serious about its personal data protection. The consent of the subject should be also taken, and for example, in a situation when the data is transferred to non-adequate countries, as we call them, similar to GDPR. If there is an agreement placed on the website, of course, no written consent and no consent is required. That's why these user agreements are always placed similar as in the EU. In Russia, we also have a similar concept called DPO, and according to the Russian law, such DPO must be appointed by the data operator. In certain cases, when there are no exceptions, of course, before starting to process personal data, the Russian operator must notify Roskomnadzor, which is the Russian IT regulator, about its intention and about its purposes and the volume of data that is intended to process. Finally, we must add that there is a special obligation which is called localization, which has recently took effect in Russia, and for for the purposes of collection of personal data and its use and further transfer, the location of the data center or database in Russia is a must. And of course, you cannot play with this rule, and you cannot get around unless you have put this personal data of Russian citizens in the Russian data center at first. Why user agreement is so important, and we talk about this today. This is because the general rule is always to ask for consent of the data subject when you collect, use, and transfer such data to others. And this is similar basically like in the EU, of course. But in Russia, there is a list of so-called adequate countries, which was approved by Roskomnadzor, and of course we are the signees to the Strasbourg Convention, which is effective also in Russia. So this list is even broader, and to these countries you don't need to ask for consent if there is basically the agreement where the data subject is a beneficiary. And this is repeated in Article 12 of the Russian personal data when we speak about cross-border transfers. In case you transfer data to adequate countries, there is no need to put such user agreement. But usually the website would have this user agreement to safeguard their interests and to avoid additional consent from the subjects. What is the data subject consent about? The data subject consent must be specific, informed, and willful, and the burden of proof that the consent has been received lies always on the data operator. That is why the opt-in forms, which Stanislav has mentioned already, are usually applied during the e-commerce business. In certain cases, as I mentioned, you cannot avoid written consent of the data subjects. For example, when we talk about biometric data and when you collect something more than just emails, passwords, emails, and phone numbers. If you collect passports, then of course the written consent must be secured. Speaking about the privacy policies, Russia has specific recommendations nowadays posted by Roskomnadzor, and these recommendations are usually followed because during the checks they prefer to read what they have clarified about. And I must say that these policies are structured and written in completely different ways from the US policies or EU policies. So you better consult with Russian data protection experts before you draft such policy and apply it to the Russia e-commerce business. There are no recommendations on cookie policies, but as I mentioned at the beginning, Roskomnadzor is planning to share some light on that in the very near future, and there are at least 2 cases where cookie files were treated as personal data. And one of them is the famous LinkedIn case where LinkedIn social network was blocked for the reason that they were collecting cookies as well, in addition to other information about data subjects. Personal data localization, what is about? Basically, it's the requirement that all data operators who collect, who systematize, who extract and use personal data of Russian citizens, they must locate their data centers or their databases in Russia, in case they basically collect it online. So, because we're talking online business today, this is the point to remember. This is the imperative rule, and it is not possible to play with this rule or to get around this rule. This slide shows that if there is a local database, you can use the dump copy of that through the hosting provider, and then you can transfer it to the main data store, which is located abroad, including in the EU. And you can see that that cross-border transfers are allowed based on the Article 12 of the Personal Data Protection Law. I'm out of time actually, and I will quickly run through risks and liability under Russian law, because non-compliance in Russia can be strictly prohibited, strictly punished, and we need to know the risks. First of all, regarding liability, there are civil liability, administrative liability, and criminal liability, depending on the circumstances and depending on the nature of the breach. Administrative sanctions have been strictly infringed, strictly administrative sanctions, they were hired up by the government, and now the fines are quite big. Of course, not as big as in the GDPR, but still they can affect the business. And administrative sanctions can be applied even for representative offices or branch offices. Also, speaking about the blockage, I must say that the websites can be blocked for non-compliance by Roskomnadzor, and the websites in breach, they are included into the register of prohibited information. That happened basically with LinkedIn case, where the LinkedIn network was blocked, and it's not operating right now in Russia. Sometimes there are cases when foreign websites can also be blocked, and this slide shows that Roskomnadzor has issued a flow chart where they explain how they can reach foreign hosting providers, foreign operators, and request information on personal data processing compliance. And in the negative, they can go to the court and ask for blockage. This slide shows the example of such blockage if the data operator stores the Russian personal data on the website, and without the data subject consent, the data subject consent or the Russian IT regulator can go to the court. Nowadays, it needs to be mentioned that Data Protection Authority, Roskomnadzor, can start case on its own and go to the court directly. Before, it was the Russian prosecutor's office that was responsible for that particular cases. And then the court, if the case is positive, issues a court decision. If it is effective, the website will be blocked. So very smooth procedure, and Roskomnadzor and courts are pretty good in that, blocking infringing websites. Now I pass the final word to Stanislav, who will summarize what we have discussed with you today, and we hope that this will be useful.
Okay, so our today's summary will be very simple. If you have an EU-based company or any other entity that is under the GDPR, and if this entity offers online services to Russian customers, to Russian users, let's say, in that way. If this is the case, when your website is covered by both the GDPR and the Russian law, both these laws, both these regulations are applicable here, and it means that you must ensure compliance with the GDPR on the one side and with the Russian law on the other side. If you fail to do so, the liability measures on both sides of the border can be substantial. That is why you should ensure that your GDPR privacy policy and other documents placed on the website do not contradict Russian personal data law, and localize them if necessary. You should process only the minimum amount of personal data. If it is possible not to use personal data, then don't use it. You should comply with the localization requirement of the Russian personal data law, and that's why you should use at least a dump server located in Russia. And finally, you should provide some contact details on your website, you should ensure that these details are there and that they're easily accessible. Because according to the procedures existing in Russia, Russian authorities almost always contact the owner of the website before blocking this website or before initiating any other formal procedures. That's why it is almost always possible to negotiate the situation and to eliminate possible data breach before any formal actions of the Russian authorities. That's why it is advisable to be open for discussion with them. So that's all for now, at least from other side. And now let's answer the questions.
Thank you all for your insight in this area. We've received a number of questions, so we can move on to these now. So our first question, if a company has headquarters in an Asian country which processes all data in a centralized processing format, should recruitment data be stored locally? Sergey, would you like to answer this?
I think this will be me, Stanislav, who will answer the question. So we have the headquarters at Asian countries which process all data as centralized processing. This is a tricky question, actually. The Russian personal data law, in particular the localization requirement, says that personal data of Russian citizens must be processed with the use of database located within Russia. That's almost literal, word by word meaning of law. At the same time, there are several exceptions from these rules. And one of the exceptions is that the localization requirement does not apply if the personal data is processed for the purpose of compliance with Russian law and for the purpose of performing obligations explicitly specified in Russian law. And of course, we have the labor code of Russia, providing for a number of obligations of an employer. And that's why many companies believe that their HR data is not subject to the localization requirement because this data is processed with a view of purposes explicitly specified in the labor code. And now the problem is that the recruitment process, for some reason, the recruitment process is not governed by the labor code in detail. This is something, I mean, the negotiations between the applicants and the possible employer, they're beyond the scope of the labor code. There are only some general guarantees and general principles of recruitment there, but there are no data processing purposes specified for the recruitment data. And that's why you should store recruitment data locally within Russia. So this is the answer.
Okay, excellent. Should we move on to question 2? One listener has highlighted that they've seen several articles reporting that there's an initiative in regard to Russian privacy law, which suggests that personal data should be allowed to be passed through multiple companies, and that these companies should be allowed to process data for the purposes they deem beneficial for them. Do you know anything about this and whether there is a chance that it may be adopted?
Well, I heard about a bill on this matter, but as of today, this is just an initiative, a bill, not a law, and that's why we cannot predict what will be the law on this matter. According to the current legislation, it is possible to process personal data in order to protect legal interests and rights of a company. And in this case, the data can be processed without the consent of the data subject. At the same time, the Russian personal data law does not provide any concept of affiliation between entities. And that's why if we have a parent entity and a subsidiary, from the perspective of the Russian personal data law, they are two different legal entities. Even if they have joint data processing purposes, they cannot exchange data just because they are affiliated. So they must comply with a number of formalities. If this law is adopted one day, maybe this procedure will be simplified because let's say the international practice, the GDPR and data privacy laws of other countries show us that, of course, it is necessary to allow joint data processing by affiliated entities. Everybody understands that, and everybody understands that this is a huge problem for, I mean, the current legislation is a huge problem for groups of companies. That's why I believe that sooner or later they will provide for specific regulation on this matter. But let's see what happens.
Okay,
let's
thank
go
you.
to the question 3.
Great. We have a listener asking, does the DPO have to be based in Russia? Sergey, I don't know if you want to address this one.
Yes, speaking about the question 3, does the DBO have to be based in Russia? Yes, the reply is basically yes, because the law says that this has to be a person, not necessarily a legal entity, by the way, which can be a LLC. It can be the individual entrepreneur, a person that is very professional, of course, in data privacy aspects, news, developments, who must be like the hub person in the company that does the training. And of course, it has to be based in Russia.
Great.
Let's do question 5 about the seminars or talks to EU person in English. Well, basically, not only Roskomnadzor, but many Russian regulators, they do not speak English, and that is why it's maybe difficult for them to do EU training sessions. But what they do, they discuss and participate with the EU government some data privacy aspects, and of course they need to be aware of the developments occurring in EU to harmonize and to systematize the legislation, national legislation we have here in Russia. So even though they are not English oriented, they do Russian seminars, and we usually report these seminars on our website or in our articles.
Thank you. Shall we address question 6? If a data operator invokes a hosting or DP outsourcing company to handle the processing on behalf of the operator, who carries the liability?
Yes, if the data operator invokes a person that is basically acting on the instructions of the data operator, for example, a hosting provider, then by operation of law, the data operator will be liable in front of a data subject unless there is an agreement to the contrary. That is why when preparing such kind of agreements, parties are free to define the liability.
Great, thank you very much for that. So to conclude, once again, I would like to thank our expert speakers for joining us today and giving such an excellent evaluation of this complex area. I'd also like to thank our listeners for tuning in and submitting questions.
I'm sorry, Tasha. Can I answer the last question about the exception from localization? It seems that I wasn't so clear. The final question for today.
Sure, yeah.
The question is, where can I find the exception from localization? And the answer is nowhere, because as I mentioned earlier, according to Article 18.2, 18.5, this rule is imperative for all data operators that are acting under the Russian law. So the option how you can deal with localization is to store the first database in Russia by, for example, hiring a dump server and engaging the hosting provider, and then you can duplicate or cross-border the data abroad because it's not prohibited. Thank you.
Thank you. Thank you again to our speakers. Thank you for our listeners for tuning in and submitting questions. As usual, we'll be circulating the slides and the recording of the webinar in case you would like to come back to it or share it with anyone later on.